detailed order. Now we can't say that we must
Ordinarily
hear
not
it
be
now.
aware of.
Because my instructions are, and I must be candid, because I haven't seen this petition.
Yes.
They
So
should have told you about
I
it.
wouldn't like to make a loose statement. But all that I'm saying is my instructions are that the relief that are contained in this petition in relation to the certification, etc., this petition was originally against the teaser. Now, all that I'm saying is
But
that
now what's happened is,
all that I'm
right or
saying-
wrong, the effect
Let
of this order, the effect of this order is that there is going to be no stay on the release of the film.
Balak,
Now, Madras has been moved, Kerala has declined to
Balak,
grant
I don't-
stay. We
Balak,
can't
I
now
don't-
grant this. Or even tell the Chief Justice, no, you must constitute a bench this afternoon.
all that I am suggesting, all that I am suggesting is, all that I am
At the end
suggesting,
of the day, what would perhaps happen?
my
It's like they have applied their.
They've applied their mind because they've already
I only seek this much in subject to your lordship. The matter is, let me get my hearing today. If I can
But
satisfy,
had a hearing,
Malad,
had a hearing.
Malad, this is not my petition. I don't know what is there.
The relief is
Malad, it is not my petition. Malad, why is there an objection? Malad, I can understand.
No,
there
but
can be a legitimate.
there can't be 5 bites or 3 bites of the same cherry.
It
Now
is
they've
not
been-
relief.
But it is the same.
He has been in Kerala.
Your lordship is-
Benches- we understand the bench there also. I wanted to see the order. If the bench had merely said SO to Monday or something. Here they've applied their mind and they've declined interim.
No, my respectful submission is, Manoj, so far as this petition is concerned, perhaps, Manoj, the compass is a little different. This focuses more on the teaser, the trailer that had come out. We are focusing, Manoj,
That's not.
with the greatest
In
respect.
fact, the relief.
I'm only saying, Manoj,
Which was a relief.
I'm just suggesting this, Manoj.
The relief is also.
No one can have a grievance hearing.
And not just the team.
I'm saying, let me have my day in court. That's all that I'm saying. Tomorrow, otherwise, the argument will be that the penny is dropped.
You would have done that.
See,
You would have
Roman
And this-
done that with
This is
you would
a
have
matter.
done that.
With
But
the great
the fact-
this is a matter which was moved before your lordship requested the Chief Justice Manoj to constitute a bench early. So therefore, Manoj, surely I should have got the hearing today. I would have mentioned it at 10:30.
See, you are.
But for the events which have happened thereafter.
Which was the bench before which you mentioned?
Before the chief.
We mentioned before the chief.
And thereafter?
Thereafter, Manoj,
This bench was not sitting.
this bench was not sitting, but we were orally told that it is not convenient for this bench to take up the matter today, so it may come up tomorrow. We don't even know whether it will come up tomorrow.
You can always go back to the Chief Justice and tell him that, look, that bench is not sitting, please assign.
Chief Justice is in leave, Manoj, he is not sitting.
There's always an acting chief. There's always someone else.
Then give us the liberty to do that, we'll do it now.
Why do you require liberty? You mentioned it, you must have mentioned it before whom? Justice Bhati is not there today, you said. So you must
Yes,
have
I
gone to
believe-
Justice
I believe-
Alexander Thomas.
Manoj, a letter was sent to the
Whom
room.
did you mention it before? Justice Thomas?
No, Manoj, a letter was sent to the acting Chief Justice. The acting Chief Justice said, I am assigning a bench orally. Thereafter, Manoj, from the registry, we got a message
That they will not be sitting.
that they will not be sitting today.
Therefore, you go back.
No, we went back. We went back to the Chief Justice, what we, with the greatest respect.
Mr.
Manoj, we went
If one
back.
bench has applied its mind.
Manoj, we went back.
How
Manoj,
many times will there be look at it from the point of view of the film producer. How many times does he face challenges?
Look at-
He's faced one challenge, the bench has said, no, I'm not going to stay the release, pass the detailed order. Now, again and again, we have to now, how many times in the same court or in different courts, they're facing something in Madras.
Your Lordship sees the influence.
But we are not
The
standing in a
implementing-
way of even now moving the acting Chief Justice. Or if the acting Chief Justice is not there, if the ACJ is not there, the J1 is always in charge, to make.
The difficulty that I face is this. I've already moved his lordship, and what we were orally told is that we can't force a bench to sit if it's not sitting on this particular day, if the judges are not inclined to sit. Because the Kerala High Court is on vacation. So there's no court to which you can approach. There's no one sitting to which you can approach straight away. I'm only saying this. If today the court is persuaded by its earlier interim order, it will not grant the relief. But let me have my day in
I got
court.
your point, but you can therefore go back right now. It's just 2:30. You can go back and inform the.
But without liberty, they will not entertain me. Your lordship will take it the penny is dropped.
Why? Well, if a bench which is assigned by the Chief Justice is not available, surely a
We
litigation.
went back to his lordship, and what we were informed was that if the bench is not sitting, then it could not really be told that oh, you have to sit today. That's what we were told.
But you
Now this
can
is all
request-
oral. So
You
indulge
can
me.
make a request for an alternate assignment if the bench can't.
Then my lords, give me that liberty unless your lordship.
There's an interim.
My lord,
interim on that.
no, because my lord, unless your lordship gives me that liberty, my lords, the penny will drop.
Won't be proper, Mr. Madhu.
My lords, kindly let me have my day in court. My lords, that's all that I'm seeking.
Many times.
Because in all fairness, when your lordship passed the order earlier, when your
Look at
lordship,
the.
Things would have been very different had that order not been there.
sorry, my lord.
Things would have been very different had that order not been there. Looks like High Court had applied its mind. There was an order which is passed.
And ultimately, Mr. Amity, one more thing.
It's very wrong.
As you told us yesterday, you're not against the film being released, but you want a disclaimer that not 32,000 women have gone to.
That is what was prayed for, my lords, by the Jamaat.
But only 3,000. Now, if that is your prayer, the disclaimer can be directed by the High Court even on.
No, that is not our prayer. In our petition, we are challenging the certificate directly. The CBI, one second.
Yes.
We are challenging the certificate directly. No, my learned junior is very well
It's all
prepared,
right.
much better prepared than I am. So therefore, I owe her an apology. But what I am suggesting is therefore, let me have my day in court. It can't be that I don't have my day in court, only because of these procedures.
But, it can't be that I will have my day in court when somebody else has had a day in court on the same film. And,
I will annex this order.
I will bring this.
It is my duty to bring this order.
and as the court said in that case, the certificate has been granted by the CBFC. Complaints regarding the teaser, which contains this offending portion, were made in November 22. And a challenge as regards the contents of the teaser made now is belated.
So the
That's
focus,
point.
is, my lords, on that petition is with regard to the teaser.
But this applies to you also because
But
you were aware of
I
the
will
teaser.
do- My
You
lord,
were aware of the teaser in November 20.
my lord, I have, my lords, now come because I am suggesting that so far as the certification that is,
What is the date of the certification?
it's recent.
Huh?
24th April.
24th of April.
Now, what happened is, my lords, your lordships are aware. First, that IA was moved before a coordinate bench of your lordships. The coordinate bench said that you must file a substantive petition. We filed a petition.
Oh, I mean, you only your client.
Correct.
No,
so we
you get your client. You get your
We filed a
contract. You file an IA in a pending hate speech matter.
I
which
would have stayed
Yeah.
surprised when I said it.
You want
We corrected that.
You want to challenge the CBFC
No, no.
certification?
Your
You
lordship
file a
has
226 petition.
My lord, 1,000. 1 second.
You go and file an IA in a hate speech matter challenging the certification. That bench rightly says go under 226. At which point of time you go under 226? You should have gone under 226 right away. And now this contrived urgency is
So I have lost those 3.
somebody, Mr.
So, Manoj,
Murthy, at the end of it,
Manoj,
somebody sings their money. The actors who have acted in the film also, they have dedicated their labor. You must also be very careful about staying films. At least I'm very, very careful about staying the exhibition.
just see, my lord, just see the.
Ultimately, the market
Just-
decides. If it is not up to the mark, the film just
So that's
walks on
so
the-
just see the teaser. My lord. Just let me show that.
Yes.
To only emphasize the urgency. I will not even read it because it is
The merits of the
egregious.
matter.
Just the one page my lord, for my satisfaction, and I'll leave it.
But
Just the one page.
no, but then we don't have that challenge before us, and we will be now seeing.
So let me have my day in court, my lords. All that I seek is 1,000 pardons, my lords, for having moved the IA. 1,000 pardons for having moved a 32 petition. Your lordship then
No,
passed.
32 petition, no part.
Very
32 petition, you are absolutely just.
Now your lordship
may not end it.
So your lordship
but
said
that's
go
the
back.
remedy.
Yes.
We will not blame you for 32.
Absolutely.
But the IA was a
Very,
little
very
bit
well.
felt, I thought.
1,000 pardons. 1,000. Now, at least
No, it's a question of choosing your remedies. You make the choices.
1,000 pardons, my lord.
It's not a question of.
I can say, I'll say it again.
It's not.
10,000 pardons.
You don't need to, because you have a right. Where is the question of?
As I said,
So therefore,
You have implications for others.
Therefore, all
Also a matter of propriety.
your lordship is right. But I will bring, the first thing I will start with is,
No,
if I get my hearing
Proper
report,
also. For us.
just one in that, just one in that. The urgency, your lordship may just see two paragraphs of the teaser.
You will not touch.
Very well. Then let me get my day in court.
The same
We
thing
said
you have
without
told
us
now.
giving you liberty specifically,
Do what
you are at liberty to move.
But I can't, because I've done it. I am presented with a fair.
That's all
We've
right.
all,
There are.
you know, Brother Patiwala and I have been judges now for such a long time, and Brother Narasimha has argued before judges for such a long time. So, you know, that this happens very often, that in a vacation, you know, the judges are not available. You go back to the Registrar General and say, sorry, those judges are not available. Somebody else will have to take it up. They assign something. I do it all the time. On a Saturday, something is
But look,
told that one of the
unless-
judges is traveling.
what I-
all right, इनके पास भेज दो.
Sorry. I'm sorry. My instructions are that unless your lordship gives me that liberty at home, and it will be a fair accompany from. I was answer because I went back to the Chief Justice after I was told that the learned judges or the bench to which it was assigned would not find it convenient to hear the matter on Thursday, and they would probably hear it on Friday. Give me that much indulgence.
Ramadi,
I'm obliged.
in any case, you will be going tomorrow before the bench. Date has been given tomorrow.
That also is not done. I don't know.
You said that the matter.
I'm sanguine in the hope.
Listed at 10:15.
So
I'm sanguine in the hope that it will come.
10:15 it is.
tomorrow 10:15, y'all appear before the bench. Make your submissions. Try to convince the bench. If the bench,
The
if
film
the bench
releases
is,
on midnight.
but no, the shows will start at least in the evening
No,
now.
on the OTT platform also it can release.
That,
It's
obvious.
the penny drops. I'm saying a lot of agony can be averted. If you give me a hearing today, it's not a normal movie. Just see, Malad, your lordships don't want to be invited to see it, but I have seen it. I find it difficult to read to your lordship. Just read it to yourself. Only from the perspective of the urgency. Just read that. And then leave it to your lordship. And I assure your lordship, Malad, at the bar, that I will start by showing their lordships this interim of
It's not about the merits of the.
I will assure your lordship that just see two paragraphs, just hand it over.
No.
Just see one.
No.
Then give me this.
What we
We are not seized of the petition. here.
Then very well.
not forces.
Then I'm only on this. I'm only on the urgency. This.
And see, look at it this way, as Brother Patiwala says, the CBFC has released the film. 1. 2, the Kerala High Court declined to stay the film, though albeit in a more restricted petition, as you say. 3, yesterday we said we are not going to entertain a petition under 32. Now for us to, you know, after these 3 steps have been completed, for us to now hear an application like this, you know, it's proper, you know.
Only
Because the
one.
high courts are not our subordinates also. They are entitled to take a view. And,
Certainly. Then only one thing, Manoj, that I wish to say is, when your lordship did not entertain the 1332 petition,
we said you can move.
your lordship said that the learned Chief Justice will take into consideration the urgency of the matter and listen. The learned Chief Justice did that. It was assigned to that bench.
But
It is only on
a written stone. If you tell the learned chief justice, the secretary, the registrar general, he will take orders from the.
We did that. We did that. But when we went there,
We are not.
or give,
Thank you. No,
or that is liberty.
that liberty you have without us giving you a liberty.
If your lordship-
liberty we normally give when, with the absence of that liberty, something would not be available. Something which is available to you.
It won't be. At the bar, Manoj, I can say I'll be presented with a fair. I've said that once, Manoj, I don't want to repeat it again. Grant me this much, at least the indulgence of moving the learned Chief Justice again in the afternoon. That's all.
You can move this.
I seek nothing further.
Thank you.
Great.
Yes,
I'm grateful for the indulgence.
Mr. Dwivedi, all of you have seen this? These terms, everybody has seen it?
I just have one or two, your Lordship may just go through it. I just have one or two comments to make. Your Lordship may just kindly go through it.
Comments means not arguments, please.
I can always make a request.
This was drafted with consent and agreement of all.
I sat with Mr. Dwivedi, so there's no problem. Let me just think.
Yes, what do you
There
want?
are two comments, my Lord. Para 2, your Lordship said indicated 8 crores, 5 monthly installments.
Right.
That's what your Lordship said indicated. My second, my Lord, request, my Lord, and by instructing of, my Lord, council is very keen, my Lord, gratuity may be paid. Because they conceded before just Dharmadhikari that they will pay gratuity. We have that on record. Gratuity, they conceded before Justice Dharmadhikari. That the gratuity we paid.
How much is the rough amount of gratuity liability that you have to bear?
5 crores for all of them.
All put together.
All put together. It's 5 crores.
Okay. That's one image policy. Then what's the next?
So this is my second point, my Lord. The third is, my Lord, Lord, since there are 31 of them, my friend is a little constrained because one or the other is objecting. Can it be in order of the court?
Yes, of course.
Because, Lord, because it's...
We don't want to put that burden on the learned.
Yes, Lord, I don't want my friend...
But some one person will say, who gave you
Your Lordship knows, Lord.
Yeah, no, that will pass.
Point taken.
We just wanted you to formulate it for our benefit.
That's it.
Just so that we don't get some.
Gratitude, Lord, that's my request.
These two. Okay.
One small point. That in the affidavit, my Lord, which we filed on 26th of April 23, your Lordship may come to the chart and last page, which is at page 14. These 74 petitioners, so this gratuity part also can be taken care of. These 74 petitioners who are non-petitioners before the High Court have been given 3 crore 19 lakhs 887 amount in the chart by the DTE. If this amount is not paid to them, because they are not petitioners, they are not entitled for interest, still because your Lordship says that all are entitled for pro rata, they charge the interest which is given by the High Court to us. The same thing they charge from 1/1/2006. So this amount should be adjusted and should be given to the petitioner as a gratuity. So this is all. This issue is all. High Court is kindly see page.
What we'll do is, on account of gratuity, we'll increase the quantum of compensation payable to 70 crores.
I'm so grateful.
My lords,
That's now final.
My lord-
No, because the moment we see gratuity, it will be all in the air. Adjudication, this, that. This will be full and final.
Full and final.
The only thing is this, Lord, of course, I will not contest once it falls from my Lordship, Lord, I
Just-
have to accept. But only I want to point out that since the college had achieved 0 admissions on 1/4/21 and my Lords have already advanced the cutoff date to 30th September 22. So if we take the closure date, Lord, it's already 13 crores is being added on account of the cutoff date being advanced by my Lord to 30th September.
All right, we'll say.
my lords, my request has not been taken care of in the order, and at point number 6, they said this settlement is full and final payment, my lords. My lords, 19 months salary, my lords, the period corresponds with the other employees, and my lords, it will not open a Pandora box because there were 62 employees.
What is your monthly salary?
My lords, it's around 1 lakh. My lords, 19 months, it will be around something around 19 lakhs, my lords.
1 lakh per month was the salary.
My lords, computer.
What is?
So he's a professor of computer technology, my lords.
They're all-
In fact, transfer was allowed, my lords. They have not given effect to that, my lords. In fact, I was supposed to be.
So the only other thing is that this 8 crore per month, Lord, I would request, Lord, that the paragraph 2 may be retained as such.
Yes.
Because the amount is heavy, but then we have to,
5 crore.
the gap of deposit is only on account of the fact that we hope that we get the permission from the commissioner and we are able to dispose of the land. But we are making the commitment irrespective of the sale of land. Even if the land is not sold, still we pay for it otherwise.
See, 5 crores per month then. Instead of 8 crores per month. Saying 30 crores by 30th November. We'll say that let that go every month 5 crores so that they get some money every month,
Yes, right. Yes.
Just
We'll say May, June, July, August, September.
That will take it beyond, my lord, 30th November also, if you lord make it 5 crores.
Instead of
Because
cash potential, I wouldn't.
it's 42 crores, my lord. It's 42.
So we'll say 5 crores for 5 months, which makes it 25 crores. And then last month, the 15 crores, the last installment.
Very well. That's 17.
Enough.
42 now, my lord. That's right.
That should be, it's comfortable for you.
It will be difficult because only of the land, my instructions are that this. But already we have from 54 crores and from 54, this is 8 and now 70.
The dispute in the present case pertains to the closure of an engineering college conducted by the appellant at Gondia. Full stop. Permission for the closure of the college was declined by the All India Council for Technical Education on the advice of which university?
Nagpur University. RTMA Nagpur University. RTMA Nagpur University.
On the advice of the RTM Nagpur University.
I had mentioned the full name.
Full stop. The High Court
You have reduced.
allowed the claim of the teaching and non-teaching staff, while
No, I have mentioned here also. I don't know.
the High Court upheld the decision to reject the closure of the college and allowed the claim of the teaching and non-teaching staff towards their wages, unpaid wages and dues. But stop. During the pendency of this proceeding, by an order dated 26 August 2022, the Directorate of Technical Education in the state of Maharashtra was called upon to compute the amount due to the employees in terms of the judgment of the High Court up to 30 September 2022. In the meantime, on 9 December 2022, Justice B.P. Dharmadhikari, former Chief Justice of the High Court of Judicature at Bombay, was requested to mediate on the dispute in order to facilitate a final resolution. Full stop. Though the Director of Technical Education, though DTE has determined the dues, the mediation has not been successful. Full stop. During the course of the hearing, several orders were passed by this court for deposit by the management towards the outstanding dues of the employees and for pro rata disbursal by the DTE. Full stop. An amount of rupees 28 crores has been deposited by the management of the institution. Full stop. Several attempts have been made before this court to resolve the dispute finally. Full stop. With the assistance of the Learned Council, there has been substantial headway in that direction, and a few niggling issues remain to be resolved. Full stop. Bearing in mind the broad interests of the employees, we pass the following order: bracket 1, the appellant, Gondia Education Society shall pay a total sum of rupees 70 crores towards the outstandings of the employees. Full stop. In full and final settlement. Semicolon, bracket 2. Since an amount of rupees 28 crores has been paid by the management and which amount has been disbursed to the employees, comma, the balance of rupees 42 crores shall be deposited by the appellant with DTE in the following terms, colon, A, an amount of rupees 5 crores each shall be deposited on or before 25 May, 25 June, 25 July, 25 August, and 25 September 2023, making a total amount of rupees 25 crores. Semicolon B, the balance of rupees 17 crores shall be deposited on or before 31 July 2023.
November.
November 2023. 3. On deposit, DT shall deposit the
नमस्कार दोस्तों, स्वागत है एक नई वीडियो
pro
में।
rata to all the teaching and non-teaching employees in terms of the previous directions issued by this court. 4. The institution in question, the engineering college, namely Manohar Bhai Patel Institute of Engineering and Technology, Gondia, would be deemed to have been closed with effect from 1 April 2021, when, into single inverted commas complete, single inverted commas, 0 admissions into inverted commas complete were achieved. In exercise of the jurisdiction under Article 142 of the Constitution of, there shall be a direction that the closure shall be in terms of the provisions of Section 121, bracket 1 of the Maharashtra Public Universities Act 2016 and the AICTE Approval Process Handbook 2018-19. Semicolon, bracket 5, payments shall be made to the employees pro rata after deducting TDS in accordance with law and the employees provident fund contributions up to 1/4/2021.
Well, this is substituted by some of the corrections at the bottom.
Yes, the management of the management undertakes to deposit the deduction made in relation to the EPF through DT with the Provident Fund Commissioner, along with its own contribution, if not already deducted and deposited. 6. The above settlement is in full and final settlement in respect of all the claims raised by the teaching and non-teaching employees in the petitions noted in the cause title, and no further claims against the management would be entertained by any authority or court. 7. The above settlement would bind all the 136 employees comprising of the teaching and non-teaching staff of the college. And 8. The Joint Charity Commissioner, Nagpur, shall decide application number 1 of 2022 filed by the management under the Maharashtra Public Trusts Act, right? 1960, expeditiously and preferably within a period of 3 months. 3 months, we must give that. Within a period of 3 months. Stop.
And any petition.
No opinion has been expressed by this court
But any
on the merits of the application
filed
by the management before the child.
There are some petitions filed for 7th commission and whether they should stand withdrawn.
And then finally you say the undertaking by the management to pay the sums as quantified in the earlier part of this order shall be irrespective of the outcome of the proceedings before the charity commission. In view of the above settlement, in view of the above direction, all the proceedings which have been instituted by the teaching and non-teaching staff forming the subject matter of the dispute in the present case shall stand finally resolved and concluded.
There are 7 pay commission recommendations claiming benefits of these recommendations. Petitions are pending, filed by the teaching staff before the Nagpur bench of the Bombay High Court Lordships. So can it be observed that because these are independent of the...
No, this will be now concluded now.
Because
They are not
Pending petitions before the Nagpur bench of the High Court of Judicature at Bombay shall stand closed.
My request is, my lord, since
High Court of Judicature at Bombay.
my lord, request is, since DT is disbursing, my lords, and my representation is before DT. And my lords, there are only 2 employees, and I am the only one who's filed representation, my lords. It is not like, my lords, it will open a Pandora box, my lords. That 2 employees, that's why I'm saying so, and my representation.
All right, all that we'll do is this, Mr. Dwivedi, just look at this employee. This one, if there's 1 or 2 employees now, we leave it to you. Just
It is a matter of 19.
You just told Mr. Dwivedi.
Well, if it's not
Because you don't know what consequences will be there for other employees. So just if there is something there, just you have a word with Mr. Dwivedi. Very sorry.
well, my lords, sir.
Just one clarification. Disbursement by the DT will be monthly as and when they deposit so that it can be disbursed.
The disbursal by the DT shall make the disbursal immediately after the amount is deposited by the management in terms of the above time schedule.
May I express gratitude, my lord, to my dear friend, my lord, that we have been able to resolve.
We are very happy. Every time it would come, you would say, what should we do?
Drastic closures sometime.
So the charity commissioner may be directed to dispose of the application expedition.
You said that.
Only thing is that we will not see your learned friend coming from Nagpur every time to this.
They need to pay my lord liberty to come back.
No liberties, please. Where is the question on liberty? Unanswered. With that, it's always there. There is always there. Another
undertaking. That's why I recorded an undertaking.
It's always there.
Yes.
The lordships have given 3 months time to the commissioner, so that will not help us. Application is pending for 1 year. The lordship said 3, decide in 3 months.
Preferably, if you wanted
1 month,
one month, the charity commissioner will find it very difficult to pass an order. He has to advertise. They have to follow all this.
Our petition is pending for 1 year already. It's not that we'll be filing.
How long will it take to tell?
Minimum 8 weeks. Minimum 8 weeks to resolve.
So, lordship
2 months. Yes, 2 months.
Express gratitude.
The learned Solicitor General was here on behalf of the...
Yes, we'll record.
He said...
He has appeared for DTA.
Yes. Good.
Item 17.
My lord, I am
Item 17.
Not complete matter.
Sorry?
Service is not complete. I am
In which matter?
item 17 minus.
Notice was issued
This
when?
is kind of a 2015
2015 matter. We'll discuss it.
Absolutely.
And you want a ban on smokeless tobacco product? How can we issue ban? You pursue your remedies before the government. Who's for the petitioner?
Respect to official something.
Proof of service has been established.
Item 18.
Item 18.
My lords, I am mentioning a matter, item number 14, my lords. I am Advocate Charanjit Chandrapal Stuhia, my lords. My lords may kindly allow us to withdraw the petition.
All right.
That was 18, is
Tell
it?
Charanjit to start private practice now. Why is he dependent on this standing council business?
14.
अच्छा 18 के निकालो क्या है?
Item 18.
18, my lords, there's a letter circulated by the petitioners.
All right.
My only request for the lords will kindly have it in July.
July
19.
19. Twenty.
19, my lord.
19.
Yes.
Is there something small which we can do right now? We just want to rapidly go through our board today.
My lord,
Don't get over.
It won't get over.
Lord, there are certain urgent directions which your lordship.
Yeah, we do this. We'll keep it next week.
No, what I'm saying, my lord, there was only one direction which the High Courts have some problems. Which, my lord, I have modified it. If those directions are issued, my lord,
Not today. We've now got, we were held up in the morning because of somebody.
I'll leave it at that. Lordship will give some date, my lord, when it needs to be heard, my lord, also.
We'll keep it in July.
Lordship will give some fixed date on a Tuesday, my lord.
Fixed date Tuesday, maybe.
On Tuesday, my lord. Very good. Please allow.
Item
As 20 mention was made, it was allowed, but now there is a limit.
July में रखा।
Well, it's actually, that's the smallest request because the mention. Any Tuesday, मतलब, Tuesday, Wednesday.
You get it right away, right? 21.
Yeah, please, Your Lordship. Your Lordship, this is actually now fairly settled because the state has already filed an affidavit.
Saying?
They have already said three things. One is that we have individual. He took an adjournment also. These people mentioned they live in plastic roof on top.
Sorry, there he is.
I'm so sorry. Some time. I'm so sorry.
What is the position now, Mr. Agarwal?
No, we are opposing the petition because Lordships will hear it whenever your Lordships.
Let me just, Your Lordships, there are three issues.
We'll have to.
No, may I just now with the, I don't know what survives with the state's affidavit now. Your Lordships may look at the state's affidavit. I can understand, I would not.
What does the state say? Tell us.
What does the state say? Right?
Please, Your Lordships,
Then we can close it.
latest affidavit filed by the state, it is filed on 27/4/2023. It's a factual status report affidavit.
This is at page 429.
Has this? Your Lordships has this.
Page 2, right?
Yes, page 2.
I found it.
So,
page 430, 429, 430.
the state is also here, Your Lordships. Now, the affidavit.
Just one second, my learned brother.
Yes, I'm so sorry, Your Lordships.
Yes.
Now, that as per the state.
This one.
Yeah, no.
Actual report.
Factual page 1, yes. Application to file factual status report with affidavit.
And Malaysia, okay.
Yes.
Yes.
That as per the status report submitted in the National Green Tribunal on 13/11, around 20 to 25 hutments and 25 semi-built houses were found on CFR, that is site in question. Actually, it's site in question. CFR is an error that one can just look at the order. It becomes very clear there's a typo. Further, it was also stated that certain semi-built houses were built up to plinth and pillar level and some had bricklaying work on them. However, none of the houses had any concrete roof. It was also stated that some people were residing in these semi-built houses with plastic covers used as roofs. It was further stated that for the past 3-4 months, no work was going on in the said site in question. That as per the counter affidavit dated so-and-so submitted in the learned tribunal, out of the 63 people of the tribal community who had kacha houses, 29 of them were granted permission under Pradhan Mantri Awas Yojana for construction of 1 room, 1 kitchen and 1 bath per person. Further, the details pertaining to the said 29 people being granted permission for construction is also set out. Then, next point, that as per site verification report dated 23/3/23 and 24/3/23 submitted by DFO, it was found that on verification and inspection of the site in question, that in the area compartment 969, out of 63 tribal people, 62 of them have received individual rights letters or IFR as they're called, and 1 community claim has been given to Gram Sabha Binega. Today,
what happens?
One is they have
What happens, is there a requirement of section 2 clearance in such cases?
I'm grateful to
what
that
we are
question.
considering.
Your lordships may just straight away come to section 4, subsection 7 of the
That's why I'm just.
Of the Forest Rights Act.
Forest Rights Act.
The Forest
Yes.
Rights Act shall be conferred
Yes.
for encumbrances and procedures.
The forest rights shall be conferred free of all encumbrances and procedural requirements, including clearance under a forest conservation.
That doesn't answer the question.
Yes.
Because whatever forest rights are conferred to you,
Right.
those conferment
Yes.
need not be as per the requirement of section 2 of the Forest Conservation Act.
Yes.
But this Pradhan Mantri Awas Yojana is not under section 2 of the Forest Conservation Act. That relates to under the scheme of the Pradhan Mantri to build, to build a house.
Yes.
So would that qualify section 2 at all?
Yes, it does.
The conferment of the rights is
those rights are specified here. What are those?
Yes.
That's
Now,
free of the FCI.
yes. So can you now I'll satisfy your lordship.
See, E. Only so far as 2E is concerned means the forest rights referred to under section 3.
Yes.
So far as
Now, please
section
look
3
at section.
conferment is concerned, you don't need section 2.
Yes, section 3 and section 4 have to be read together. What does section 3 say? Please look at section 3, subclause A. It says, forest rights of forest dwelling scheduled tribes and other traditional forest dwellers. I am a forest dwelling scheduled tribe, which is Saharias, there's no dispute. Now, what is my right? My right is
Right to hold and live in the forest land.
Yes, I have a right to hold and live in the forest land under individual or common occupation for habitation. So I have a right to live there. Am I to live in?
No dispute about that
Yes.
at all.
So therefore,
The house that you are constructing is within the fourfold of a forest habitation under this act is the question.
yes, it is.
What kind of a building you are building, you don't know.
No, they can answer that. It is a one-room set. It is a one-bathroom. Yeah, please.
Let me just check.
Lord, may I address your lordship?
Yes, Mr. Commissioner.
Lord, if your lordship see the act, and if your lordship see the definition of 2T, it defines forest land.
Yes.
So, Lord, on the last date, your lordships had inquired about the nature of the forest. So it covers that. Forest land means land of any description falling within any forest area and includes unclassified forests, undemarcated forests, existing or deemed forests, protected forests, reserve forest means the forest.
नमस्कार दोस्तों, साल 19
Now, your lordship sees section 3.
A.
For the purposes of this act, the following rights which secure individual community tenure or both shall be the forest rights of forest dwelling scheduled tribe and other traditional forest dwellers on all forest lands, namely right to hold and live in the forest land.
Under the individual or common occupation for habitation.
Yes. Now, Lord, there are other rights also. For the moment, I don't want to trouble your lordship with the other
Where
rights.
do you get this that you can put up a construction?
Now, just section 4. Section 4. Section 3 recognizes the rights. Just see section 4 now. This is a 2006 act, Lord. So when this act was made, the legislature was conscious about the 1980 act, which provided that if you want to do any non-forest
No
activity.
dispute about all that.
No.
It's the extent which this act permits.
Yes.
Whether they are within this extent is the question.
Yes. Now, just see section
Tell us
4, my lord. Just see section 4. Notwithstanding, it starts with the non-obstantive clause. Notwithstanding anything contained in any other law for the time being in force. So, my lord, this will why this language is used, the non-obstantive clause, because there is a Forest Conservation Act, and subject to the provisions of this act, central government hereby recognizes and vests forest rights of section 3 to these people.
Now see A.
Yes.
There's no difference. And see what is vested.
Yes.
The forest dwelling scheduled tribes in states or areas in states where they are declared as scheduled tribes in respect of
yes
all forest rights mentioned
in 3.
But it doesn't contemplate, building, setting up pakka construction.
No, Lord, what my respectful submission is.
There's one more.
at page 60, my lord, of the appeal paper. This particular Saharia tribe, which resides in this particular forest in Shopur district of Madhya Pradesh, they are, and there is an Institute of Governance report. It says they have done a detailed study about these tribes, and the report says, it is on record, that if you see their houses, they are like prehistoric scene. So, my lord, since they were residing in those places for so long, and the houses are of prehistoric scenes, my lord, the government decided to provide them a Pakka house under the PM Awas Yojana. It is just one single room with a toilet and a kitchen. On the existing place, it does not require cutting of any trees.
How many units are there, by the way?
Lord, there are out of 63 persons were granted individual forest rights. Out of 63, 29 were identified for the grant of benefit of this Yojana. And out of 29, 23 were semi-constructed and 6 have not been constructed because your lordship passed the status quo order.
And why are you here? What further relief are you seeking? Are they seeking to demolish it?
Yes, they have ordered demolition, your lordship.
Rule or anything prescribed under the Forest Rights Act, which prescribes what is the nature and extent of a holding, residential holding that can be there. Are there any rules made with respect to
No, there are also rules.
Rules, yes, there are rules. Identification
Does your lordship's act has the rules? The rules have?
Yeah.
Rules like forest dweller rules. Just a form is.
Does it?
Miss Shinoy, you have to find some way out because you have to say that you can construct Pakka structures.
Indicate what is the extent of construction of a house for a person to whom forest right is granted.
Right.
Number one. Then after that, fact, what is the extent which is already been built?
Yes.
These are the two things you will have, whether it has exceeded or it was less than that.
Let me not hazard guess. Let me find out and get back.
Tell us that.
I am aware.
Look, we also will be extremely.
I do know this.
Extremely reluctant to order demolition because we see that these are, as
Your lordships,
Mishra said, these are
original
tribes. The government wanted to make some little to give them a
we have
side
fought for forest rights.
It's a photograph.
yes, and your lordship, they are a particularly vulnerable tribal group. Even out of the tribal group, they're the worst.
I know. You have to help us with the.
No, I will.
Find that out and tell us.
I'm very sure about the extent of cultivation, but about housing, let me get back to your lordship.
Consequences on law also will have to be considered because then if they're in forest land, then because if the government takes a stand that I can give under Pradhan Mantri Awas Yojana, then it will apply across the country. And the government of India has taken a step.
Yojana won't apply.
Sorry,
that I'm very clear. Pradhan Mantri Awas Yojana might only give you money.
Yes, Vilas.
But the scheme contemplated under that Yojana to build an extent of house
in the forest
unit can't apply to forest
land. So the government of India raised an issue with the state government, saying you give it in the revenue land. Nobody is stopping them.
That construction can't be beyond what's permissible. You find that out.
Yes.
Grateful.
But not, your lordship, just to satisfy your lordships, it's not that they do anything more. Where it is kacha, they're making it pakka. That is what it, and I'll show the photographs. But your lordships are right. I'll get back to the rule.
Union Ministry of Environment and Forest is also a party. Lord, if your lordships may seek a response from them also, my lord,
Whom?
because Union
Yeah.
Ministry of Forest and Environment.
Their parties here?
They are a party, my
They
lord.
are party. They filed an affidavit also in the NGT.
What do they say?
Page 192. They said they have raised this issue with the government of Madhya Pradesh. Page 192. Saying how have you permitted it in the forest land? Page 192.
They are also not with the government on this.
Check that up, please.
Page 192. Your lordship should have.
Your lordships prevented.
Who's appearing for the Union of India?
It is further submitted that the answering respondent as well as regional office Bhopal of answering respondent has raised the issue with the state government with a letter dated so and so. It is submitted that response is still awaited. So the government of India has actually raised this saying, plus what will happen? Today it's one house, tomorrow it will become 2 rooms, then the whole forest will start getting diverted.
Your
That's my
lordships, I know lordship stopped me last time, but your lordships must also, this is a gentleman who's a Mahant who has taken over CFR and he has
We are now on the question.
on his
Whatever we decide will apply in India.
Yes.
This is certainly not something we can gloss over.
Yes, Bhati is appearing. Will
somebody to appear.
Yes, Tanu says he will be.
So when should we list it?
anytime, your lordships in July.
Should list it in July.
Right. Grateful to
Look, this writ petition challenges the virus of Section 62(5 of the People's Representation Act.
Yeah.
The counter is awaited from the Union Minds.
Right. There's a couple of preliminary objections. If my lord's wishes, we'll file a counter affidavit.
What is the preliminary objection?
That's page 99. He has in fact disclosed it. A 3-judge bench of this honorable court has upheld this exact provision.
Where is that page?
Page 99 of his petition, Anupul. It was challenged and has been upheld. My lords, may just see paragraph 1, Justice Verma's judgment. PDF 113.
Yes.
But the issue was a little different in this matter, my lords. Let them file a counter, we will respond to that.
No, but why? In view of this judgment, why should we reopen the...
Twice over, my lords. Even in addition to this judgment, twice over by the Supreme Court.
Which are the other matters?
My lords, 1984 2 SCC 442.
1984?
2 SCC 400 page 442. The Supreme Court has gone into that question.
You got a copy?
Yes.
So I'm being led by Mr. Ritin Rai. And it is management's password fact that
This tested by a person aggrieved. This is not a person aggrieved by the provision.
There's absolutely no factual foundation, my lords. It's an academic challenge held by this honorable court by 3 judges.
And which is the other matter?
Plus, there is one more judgment which is unreported. I'll give a copy. Please.
This is clearly covered by a 3-judge bench.
And even another one.
And in the absence of any personal grievance, there is no cause to this petitioner.
Okay.
He has not been denied under the provision.
The challenge to the constitutional validity. The constitutional validity of the provisions of Section 62(5) of the Representation of the People Act 1951 has been upheld by upheld by a 2-judge bench of this court.
3 judges.
Mahendra Kumar Shastri versus Union of India, 1984 2 SCC 442, and later by a 3-judge bench of this court in Anupul Chandra Pradhan versus Union of India, 1997 6 SCC page 1, page 97 को दूसरा वाला मिल जाएगा. In view of the, in view of these decisions, we're not inclined to entertain the petition under Article 30 petition process.
Being led by a senior minds. I don't want a petitioner to be disadvantaged.
So far.
Give a password, short password, but I can take it 4 to 4 minutes.
WPC 1028 of 1990 as well. There's another 3-judge bench, which I have got.
Yes, sir, that.
बंद हो गई। अब आज जाके बोल्ड वाले के फोन से 1 घंटा बढ़ा दी। मामा और बोल्ड वाले का दोनों का फोन लिया था और तीसरा ठुकरा दिया।
ये ब्लैक क्यों हो गई स्क्रीन?
पता नहीं।
पीछे से साउंड तो आ रही है।
serious issues about arbitrability. So your lordship may make that observation about section 16, right?
Absolutely.
But I think that should, there are.
Should be appointed. It's based in Delhi.
It is based in Cochin. Any district judge, because the claim is a small claim. It's a small claim. 1.5
Now, tell us the name of a district judge in Cochin.
May I just, Paul Simon.
How much is the claim?
1.5 crores. 1.5 crores an interest.
Tell us the name of a district judge. Both of you can tell us.
I won't be able to. 446, we suggested the name of one 452 Miller.
Does the
Paul Simon.
Does the High Court have a arbitration center, Kerala High Court? We can ask them to nominate.
No, they do not have it.
I think Kerala has a. In the ONGC matter, they cited various rules, etc. Maybe they don't.
Since the claim is Paul Simon, a retired district and sessions judge, Kudaraman Edapalli at 452. We have no difficulty if my lords have somebody, some name. We have no difficulty at all. Unless they have an official's name. But can we?
A young member of our bar. It's a 1.5 crore.
I know. Right? Yes, absolutely. We have no difficulty. Absolutely.
So, in view of the arbitration agreement between the parties, both the learned counsels for the petitioner and the respondent have agreed to the appointment of a sole arbitrator under the Arbitration and Conciliation Act 1996. Stop accordingly. We appoint Mr. Dagen Basant, counsel practicing before this court.
Your Lordship, he has to be based in Cochin. That's the only difficulty.
Online is?
Online, but the seat would be treated as in Cochin. Yes, very well. Online, there are no difficulty at all. No difficulty. No difficulty. Online, difficult. Absolutely.
As sole arbitrator, stop. The arbitrator shall fix his fees in consultation with the parties. Stop. Since the parties have stated that they would request the learned arbitrator to conduct the hearings online. Stop. The arbitration petition is accordingly disposed of.
Much obliged. Lord, the arbitrability aspect, Lord, section 16.
All rights and contentions, including on the aspect of arbitrability.
Yes.
Kept up.
Yes, great, sir. Kept up. Much obliged.
25.
But you put for us, I just mean something really.
I am appearing on behalf of state of UP, but my lord only issued notice to FSSAI.
To know what steps they are taking.
Yes.
Who's appearing for FSSAI?
Your Lordship, I am appearing for FSSAI. We have filed a counter affidavit yesterday. A detailed counter affidavit has been filed. In case if they can have a look at that particular thing.
Anything else now with that counter affidavit? Who's for the petitioner?
Maharaj, we don't have any instruction regarding the petition.
Close it.
As far as the contender, the chief secretary.
What have you just tell us in a minute? What have you said?
Your Lordship had given 10 directions.
Yes.
10 directions were issued by your Lordships. And what are the steps that we had taken to comply with all those particular 10 directions has been clearly mentioned. It was basically with respect to the infrastructure ability, testing laboratories, how you are going to test the samples, what are the additional steps that we are taking to implement this act. So we have clearly mentioned each and every.
What's your name?
My name is Sharad. Sharad Nandiya.
Sharad?
Sharad Nandiya.
You know, behalf of the Food Safety and Standards Authority.
I think 2020.
Yeah.
It's on.
Oh, it's already on.
What is the name of the deponent? Ranjit Kumar Singh?
Manish Kumar Bhaskar Naik.
Again later. In pursuance of the order of this court dated 17 February 2000.